difficult to put a positive spin on this legislation, isn't it? But this is one area where you can.
Yeah.
There really is the opportunity for agencies and end users to collaborate here. You can avoid these penalties. You can avoid these claims for compensation around zero-hours contracts, lack of reasonable notice, curtailment, modification, all of that, penalties, if you communicate properly. So if you've got a good arrangement in place where you both understand each other, good lines of communication, no one can blame anybody else for having sat on their hands, you are going to avoid these claims.
Hi and welcome back to Orca Pods. We're back. Season 2 is going to be bigger, better, more informative than ever. And let me waste no time. I am going to say it. I've got legal royalty opposite me today. I am delighted, honoured and genuinely grateful to have you here. Paul Chamberlain from JMW Solicitors. Thanks for coming, Paul.
You're very welcome indeed, and it's an absolute pleasure.
Do you know what? Why don't you tell everyone a bit about you, what you do?
I can do that. Yeah, I can do that. I've been doing this job for far too long. I'm a qualified lawyer, been practicing for about 31 years, and I've specialised in employment law really from day one. But about 25 years ago, I got into the recruitment sector, started to work with some recruiters and realised that actually there was some quite specific legal needs in that sector. And since then, most of my practice is working with recruiters or people in the recruitment supply chain. I work at a firm called JMW. I head up the employment team there. We're about 600 people at the moment. Our main office is in Manchester. We've got an office of about 120 people in London and a smaller office of about 30 or so people in Liverpool. And we turn over as a firm about £90 million. So we're in the top 50 law firms in the UK. And most of what I do is acting for employers rather than employees. We do act for employees, but it tends in the main to be for employers. So I will be defending people in employment tribunal cases, taking people to court for breach of their restrictive covenants. And obviously the topic we're going to talk about today is central to all of that.
And actually, let's just jump straight in. So we're going to be talking about the employment bill. Obviously, what we've got to discuss today, it's impossible in 90 minutes to be able to discuss from the top to bottom of what's going on. So we've actually broken down some topics, haven't we? That is it your opinion that you think that these are the most prevalent at the moment to be aware of, or?
Yeah, I mean, this is a big piece of legislation, and actually, even when it gets royal assent, it won't be completely clear how a lot of the provisions are going to operate. This follows the usual practice, which is a framework, which then gets royal assent, so it becomes law, but not all of the provisions will come into force at the same time. So it'll be a sort of staged implementation over the course of probably 18 months to 2 years, we suspect. So there's some detail in the bill. I mean, it runs to 160 odd pages, so it's a fair old tome. But we're expecting a lot more by way of what we call secondary legislation, which will give us more detail, the detail that's missing, and give us more of a steer as to how we'll need to implement and interpret things. So yeah, it's huge.
You actually, sorry to cut across you there. You called it generational, didn't you?
Oh, without a doubt, and it's literally generational. The last employment rights bill, which became the Employment Rights Act, was in 1996.
Wow.
And that did change things quite radically, but it's on a completely different level to the bill that's going through Parliament now. This is radical change. This is introducing new concepts that we've never seen before. It's changing a lot of what we're used to, and it will impose a lot of additional burdens on employers. So it is absolutely generational, yeah.
And I think that's the other thing is it impacts every single business that employs individuals, doesn't it?
It does. It from the small one-man bands right the way through to the multinationals, 50, 60,000 employees. It's an across-the-board radical rethink. And it's very much in line with the Labour Party's approach. I mean, none of this was a surprise. In the lead up to the election last year, we knew exactly where the Labour Party stood on some of these topics.
Yeah.
And I think it's fair to say the unions have had a significant input and involvement in developing some of the themes.
I think that was the worst kept secret of it, though, was the union's involvement. Just quickly, before we get into the crux of it, from an opinion standpoint, do you think it's fair to business and employees? I know obviously a lot of it, but the reason I ask that is, and again, as we get into the crux of discussing the certain elements and the certain topics that we'll discuss today, there's a hell of a lot more now that as a business owner, I have to be aware of from a cost standpoint, from potential systems, processes.
Yeah.
Was that taken into account, or is it because it's so employee focused that was almost, that's the reality?
I mean, I think to be fair to the government, their position is that this is an even-handed piece of legislation. It provides extra, it gives extra rights, it gives extra support to employees. But you've got to recognise that that's from a rather left-wing perspective. The Labour Party's view and the union's view is that really employees have had a rough ride over the last 14 to 20 years. And it was time for a reset. So when you read the spin says we've tried to strike a balance here between employers and workers. My own personal take on it, for what it's worth, is that I think it goes too far in favour of workers. And in an environment where the government is saying that its primary focus is growth, my worry is that a lot of these additional burdens and a lot of the additional cost will stifle growth rather than improve growth.
I 100% agree. And without going down a political bypass here, I think when you add other things that have been implemented in the budget, et cetera, I think when you marry all of that up, I'm in complete agreement. I'm not sure that it's the pro-growth approach that is widely articulated in the media.
I agree entirely with that. And the other thing I think, Rob, that I'd just throw into the conversation at this point is that it's an area that hasn't had a lot of publicity, but a good proportion of the bill is actually focused on changing trade union rights.
Right.
So making it a lot easier for unions to take industrial action. So there'll be changes to balloting requirements. One commentator has said that this bill takes us back to the pre-Margaret Thatcher reforms of the late 1970s and early 1980s.
Right.
So, we haven't got time to talk about that today. That's a whole podcast in itself, it seems to me. But it's a big part of the bill that there hasn't been a great deal of focus on. And that, I think, just lends weight to what I said earlier on, which is the unions have been intrinsically involved in the drafting of this piece of legislation. And they will be in a much better position if it gets when it gets royal assent, they'll be in a much better position. And my worry there is because it'll be easier for people to take industrial action in an economy that is stagnating or isn't growing very, very, very quickly, more people will be inclined to take that action. So to me, there's the possibility of this becoming a sort of ever-decreasing circle. But what we're going to talk about today, I think, is primarily the individual rights that people will get rather than the union rights. And maybe we cover off the union angle on another podcast.
I think for me personally, I think there's so much that needs to be discussed. And I think interestingly, what you've said there about the unions, I didn't know that. Now, a lot of, as we sort of roll in the same circles to a certain degree, I'm not saying I'm an encyclopedia of knowing everything else, but if I don't know how many other people don't know that, what impact can this have short, medium, long term when it does reach royal assent? What sort of industries are really going to have to have their wits about them, so to speak.
Yeah.
I think there's definitely traction, and certainly I think we should talk about that on another podcast as well.
I mean, just as a final point on that, in this sector, in the recruitment sector, it's never historically been heavily unionised. But one of the aims and objectives of the trade unions is to try and increase their footprint. So they may well use these changes to recruit new members who wouldn't otherwise have become unionised within this sector. So it might be that we end up with a lot more agency workers becoming union members because of the additional protections that they'll get as a result.
And that's because it'll be attractive.
Yeah, exactly.
Christ, which is technically, when you look at it, pretty dangerous.
Yeah. I mean, I've got to be very careful not to take a political stand on all of this, but I've always tried to be very objective about this. You get a lot of people in my position who scaremonger.
Yeah.
Well, I don't think that's appropriate. I think it's important to educate people so that they know what is coming down the line. But in reality, I don't know for certain how all this is going to turn out. I think the best prediction I can give you is that there are going to be a lot more employment tribunal claims. And you may say, well, that's great for you, Paul. You make a living out of defending people who are facing employment tribunal claims. And I'll take that on the chin. I mean, I think that is absolutely right. We expect to be a lot busier. But do I think that's a good thing for the economy? Well, I'm torn. No, I don't think it is a good thing for the economy, to be honest. And I know we're going to talk about the Fair Work Agency a little bit later on. There's some interesting features about that sort of play into the tribunal scenario, but we can cover that off when we get to it.
Yeah, and you know what? I could sit here and talk to you all day, but I'm conscious we have got some points that we want to cover off. So, look, first and foremost, obviously, I had a conversation before the podcast. We've done some prep. So we've got our list here. The first, obviously, on that is the timing and implementation.
Yeah.
I think what would be beneficial is if you can just give a brief synopsis on what it is, what it means, impact, and I will say this out loud. Obviously, I'm a complete novice in this, so there's probably going to be some facial expressions and some questions that.
Don't worry, I'm a novice at lots of other things. So I've got the advantage of having done this for 31 years. So I'm a lot more familiar with the concepts. But in terms of timing, when we got the bill, well, first of all, the government said it would put a bill before Parliament within the first 100 days, and it did that. It did it on day 100. So no one was too surprised. Initially, there wasn't a clear view as to what the implementation timing might look like. But I think as the bill's gone through the Commons, because it now has finished its progress through the Commons, it's now with the Lords, and the Lords are suggesting some amendments to it before it comes back. The view was that we maybe wouldn't get royal assent until later this year, or possibly even early next year. I think the revised view is we may well get royal assent before the summer recess.
Okay.
Yeah.
This year?
This year.
Oh, wow.
Now, there's a lot in the air in relation to that. If the Lords takes a long time to deal with its amendments and pass it back, then it may not be summertime. But there is a distinct chance that it'll get royal assent before summer. So if that happens, what we think is that there may well be some provisions brought in before the end of the year, but the majority will probably come into force either next year or possibly even in 2027.
Right.
So it's that sort of time frame that we're looking at. The question someone tends to ask me next is, well, which bits do you think might come in this year? It's not clear, and it's a bit of a mug's game to try and predict that. But there are some relatively easy wins, and we'll probably talk about a couple of them as we go through the other topics. But that's timing,
right?
And sorry, maybe just one other point on timing. When the bill was published, there were a lot of things not in it,
right?
That the Labour Party had said they intended to legislate on. So when they published the bill, they published another document called Next Steps, which is everything that wasn't in the bill, but which we were anticipating would be, with a little note that says, well, all of this is quite difficult and we really need to think long and hard about it before we legislate, but we fully intend to legislate before the end of the Parliament. But this is not for now. So if anyone's interested in looking at that next steps document, if you're not already frightened to death when you look at the bill, have a look in the next steps document, because there are all sorts of wonderful things in there that are still on the government's agenda.
Given obviously the first 100 days, and I understand that with any government that obviously comes into power, has this been rushed to a certain degree?
Yeah, I mean, my view is, and I've had the misfortune of having to read all of the 160 odd pages, it is very complicated. There are some errors and there are some omissions, which I think the Commons and the Lords together hopefully will deal with.
Right.
But yeah, I don't think any reasonable person can say it wasn't rushed. The 100 days deadline is a very false deadline. It's all to do with PR and spin, isn't it?
Picture politics.
There would have been much better, it seems to me, to have taken a bit longer to get their ducks lined up and to presented something that, when you read it, makes a little bit more sense. And look, I ought to be happy that we end up with an act that is incomprehensible in parts, because that will keep me well and truly occupied in litigation. Lawyers thrive on poor drafting, on clauses or provisions in bills or acts that don't seem to make obvious sense. So, in one sense, the litigation piece for me is very, or the potential litigation piece is very encouraging. But if I'm being honest with you, I would much rather know what these things mean, because clients come to me for advice, for certainty. And unfortunately, on this piece of legislation, I think that I'm going to have to be saying to them, well, you know what? I'm not entirely sure I understand what that means. And that doesn't enable them to plan properly for their business moving forward.
I was going to say, that's quite a precarious position for any business to be in. And I think just it probably lends itself to, very off the cuff, I had a conversation with my wife, and she was one of the first people that I spoke to about this. Her business was very ahead of the curve, obviously, when they knew it was coming in. And when she came home and told me something, I was petrified. And that was at a point where I knew nothing about it.
Yeah.
Even hearing you say that, even now, and someone like you who is an absolute expert in it, that you still, with some of this, don't know how to interpret that. How is that beneficial to any business?
I could say, being as long in the tooth as I am, that it is the same, with a lot of legislation, and that's why we've got the courts and tribunals. They are there to try and interpret what all of this means. And look, I'm not saying that we're going to be in this situation forever, because, as I said at the start, there's going to be a lot of secondary legislation that will put some meat on the bones of the Act. I just hope that secondary legislation is drafted in clear and unambiguous terms, because if that's not, we really are in a pickle.
So consequentially then, what could that mean if it was in a worst case scenario where it wasn't? Well,
in worst case scenario, some things could get bogged down in litigation for a long, long time.
Right.
The highest court in the land is the Supreme Court. And if they take a view that something is so important that it needs them to arbitrate or to give a view, we could be looking at things taking years to get to that point. 2, 3, 4, 5, 6 years easily. And in that period, all you have is uncertainty.
Right.
But that's the way our system operates. Sometimes the government will jump in if it recognises something isn't working in the way that it should, and it will re-legislate or amend. But most of the time, it's left to the courts to decide. And you know what? Being an old cynic, I actually think that governments sometimes want to abrogate that responsibility to the courts and say, right, guys, you sort it out. We've given it our best go. We don't really understand what it means either, so we'll leave it to you. And it avoids, it avoids the political fallout.
And then you get a legal definitive then as well, don't you?
You do, or at least you hope you do. You hope you do. I mean, the Supreme Court decision on gender and biological sex recently is a very clear decision, but there are two sides to the story. One side is very much in favour and supports the decision. The other side really thinks it's a retrograde step. So you get clarity, but it doesn't always play out for both sides.
Watch this space.
Yeah, watch
clearly.
this space, I think, yeah.
Okay, so if we get into, we've got some pretty big topics here. So unfair dismissal. So again, I did some very, very brief research, deliberately so, because actually I'm really looking forward to being educated by yourself here. One of the key caveats is that, in essence, this can be claimed from day one, can't it?
It can.
Which is enormous for any business.
Yeah. And I go back to the phrase you used, and I confirmed it's a generational change. So the law of unfair dismissal has been on the statute book since the early 1970s, and there's always been a qualification period. So it started at a year, it went to 2 years, it went back to a year, and a few years ago it went back to 2 years. So it's sort of swung backwards and forwards, but there's always been a qualification period. What the bill will do is it will remove that qualification period. So you're right, the minute you walk over the threshold of your employer's premises on day one, you will have unfair dismissal protection. Right. And that is radical, because of course a lot of people call us now, tell us about a difficult employee and say, right, if we sack this employee, Paul, what's our potential exposure? And in most cases, the first question you ask is, how long has Mr. Smith been employed? And if the answer is less than 2 years, you give one type of advice. You'll normally say, well, you probably don't have to worry about an unfair dismissal claim. I mean, there are some exceptions to that 2-year rule. But the route through to a sensible outcome is much more straightforward if the person doesn't have the qualifying period. Now we're going to be in a position where we've got to give a much more comprehensive view, a slightly more complex steer, because that person will have protection. So that is a radical change. What the government have done, I think, however, is they've tried to accommodate the objections, and they've come up with this probationary period, statutory probationary period, which I'll maybe talk a little bit about. And it's important to say, if you read about it, don't be misled into thinking that it's a qualifying period by the back door, because it isn't. So what will it be? We think the statutory probation period will be 9 months.
Yeah, I read that.
But it may not be. It may be more or less than that. I think there's been some infighting within the government as to whether it should be 6 or 9. But 9 sounds as though it's the favourite at the moment. And what will that mean? Well, it will mean that for the first 9 months, every employee is on probation. And what we think the government will allow employers to do during that period is have a slightly lighter touch approach to the dismissal of that person, and possibly even have to pay less compensation than they would otherwise.
Right.
So if someone's outside their 9-month probation period, they will get the full protection of the law.
Okay.
And there'll be the proper procedural requirements. There have to be a good reason for dismissal. There has to be a process followed, and the person will be entitled to compensation on the normal basis. But in the first 9 months, what we think the government are saying is it will be marginally easier to terminate someone's employment without a finding of unfair dismissal.
Right.
And if there is a finding of unfair dismissal, the compensation may be lower than it would otherwise be. So effectively, that's a SOP. That's them saying, look, we are going to give people this right from day one, but to help you in this probationary period, if it's not working out, we're not going to require you to face the full force of the law, as it were. It'll be a slightly watered down arrangement. Now, goodness, great for me, because me and my colleagues will still be asked to walk an employer through some sort of process, whereas at the moment the advice is reasonably straightforward, unless there's a protected characteristic involved under the Equality Act. But when the law changes to give people rights from day one, there will have to be a proper process followed of some description, maybe a slightly different process than it would have to be after the 9 months, but there's a process nonetheless. And I think even just talking this through with you makes me realise just how easy it is going to be for people to bring claims. You can get a technical knockout now.
Yeah.
You can say to the judge, this person's not got 2 years service, or sometimes even the judge reads the papers before the case has really got off the ground and writes to the claimant and says, I'm just looking at your papers, doesn't look as though you've got 2 years service. On that basis, unless you can explain to me why this case should go forwards, I'm going to strike it out or dismiss it. The judge won't be able to do that in these cases, because from day one the person's got the right to bring the claim. So there will be more contested claims, more hearings, there'll be more judges required. I mean, the tribunals are already bursting at the seams with cases that they can't handle because they've not got the admin resources.
Of course they are.
And they haven't got the judges.
And now we're just going to put a potential skip load more on them.
Correct. So there's going to need to be some extra resource, it seems to me.
Is this in play now? Obviously, you've been saying that over the course of, since it was introduced, 2025, 6, 7, is the unfair dismissal, is that changed as of now?
No, because the act's still, it's not an act, it's still a bill. So the bill's got to finish its process through the Commons and the Lords.
Right.
The King's got to give royal assent.
Okay.
And then at that point, the government will say, right, okay, these bits here are going to come into force on these dates.
Right.
These bits here are going to come into force on these dates. So not yet.
Okay.
But when you asked me earlier on, what do I think timing looks like? This strikes me as a relatively easy win for the government.
Yeah, agreed.
The bill could get royal assent, and it seems to me within a matter of a few months, possibly in weeks, they say, right, from this date, it's zero continuity required to bring a claim.
So again, from any business's standpoint, preparation right now is key, like right now. And I think
absolutely
that, obviously these aren't conversations I have, but does it worry you how many businesses aren't prepared or are maybe looking at it and through no fault of their own, might add, but it could be 2026, it could be 2027, and it actually just ends up getting dropped in everyone's lap?
It's always worried me. I'm old enough to remember the agency workers regulations.
Yeah,
and with the Association of Labour Providers, who we've got a very close relationship with, we did a series of road shows. I remember getting up at the crack of dawn to travel to Southampton and to Scotland and do these sessions. They were pretty well attended, but not every member of the association turned up to these workshops, to these road shows. And I used to talk to the then chief executive about it, and we both were worried as to how many people really weren't sitting up and taking note. Now, we've already run some sessions on the Employment Rights Bill, as you will imagine, and we've got some more planned. And take-up's been good, but I have to say people have not been banging the door down. And I think with every piece of legislation, the closer you get to D-Day, the more people realise, actually, do you know what? We maybe should have looked at this 6 months ago.
100%.
And then panic sets in, and then they make mistakes. So you doing this is absolutely bob on.
I was about to say that's why I'm so grateful to you, is because actually I care about business and I want every business to thrive. I also understand priorities that should be priorities aren't always. And obviously having your expertise, your knowledge, and also just what I love the most, just saying it how it needs to be said, is anyone listening to this, hopefully the penny is genuinely dropping as I look into the camera and say this. You need to speak to this man if you're not already on the road of getting things implemented and processes sorted.
And look, if someone said to me something's going to change in September of 2026, and it's May, June of 2025, I'm probably going to be focused more on the day job, aren't I? I think that's just human nature, isn't it?
Look, from an umbrella side, we're seeing it with the changes for April 2026.
Yeah.
You know, the legislation hasn't been written, lots of speculation, but businesses, still too many, in my opinion. When it's published, then we'll deal with it. Yeah. So that probably is a off-topic caveat, but it pretty much marries up to what we've been saying.
I think you've got to have a contingency for this,
100%,
because this is not going away. You know, this is not going. This is not just pie in the sky. This will actually happen. The question will be when.
Yeah.
And the question will be whether you're ready for it. So, I mean, I entirely agree. The more you get your mind around it now, it might be that you decide not to necessarily do anything about it for a few months. So you at least need to understand what's going to happen. And if, you know, there is a bit of me that says, be careful, because doing too much prep could actually push you in the opposite direction.
Okay.
You may end up doing things that don't need to be done, because things will change between now and then.
Yeah.
But I absolutely think you need to be aware of the broad framework.
Okay, so probably a good tribunal time limits is probably marries nicely onto the unfair dismissals.
Yeah, and I think that is another easy win.
Yeah.
So,
because it's going from 3 to 6 months, is that right?
Yeah, correct. Now, most tribunal time limits are 3 months from the act that you're complaining of. So, for example, in an unfair dismissal case, you need to bring your claim within 3 months of the effective date of termination. Now, it is technically 3 months. That's the primary limitation. But because you have to involve ACAS and you have to get what's called a pre-claim conciliation certificate before you can bring a claim, it is possible to extend that time limit by a few weeks.
Right.
Yeah, depending on when you get ACAS involved. But I always say that's a sort of added advantage or cream on the top. You should really be focused on 3 months. Focus on that as being the primary limitation. There are some claims where the limitation period is longer than 3 months. So here we're only focused on the ones where the limitation is 3 months. Discrimination claims are another example.
Yeah.
If you want to bring, for example, a race discrimination claim, you've got to bring a claim within 3 months of the last act of discrimination.
Right, okay.
Yeah.
Makes sense.
If you're outside that period, then you can apply for an extension. It's quite tough to get the judge to grant you an extension. So you really do need to be focused on it. Now, overnight, those 3 month time limits are going to double to 6 months, as you've said.
Yeah.
And if you say that quickly, you'd probably think, oh, so what? Definitely an advantage for the employees or the workers.
Yeah.
Because they sometimes don't know that they've only got 3 months. And by the time they've got their heads around it, 3 months has gone. Yeah. So 6 months gives them a little bit longer to think about it, or to realise that they've got an opportunity. Or in some cases, employees or workers aren't up for it, and they say, do you know what? I'm going to consign this bit of my working history to the dustbin and I'll just move on with my life. 6 months, I think, gives them time to reflect and maybe change their mind.
Agreed.
Yeah. And all the time, the employer is sitting there biting their nails. And I said at one event last week, you know, you're going to have fewer nails, it seems to me, because you've got to bite them for longer when 6 months becomes primary limitation. And again, we talked about certainty. There's then less certainty. After 3 months, 3 to 4 months, you know reasonably confidently that you're not going to get a claim from Mr. Bloggs, who you sacked 3 or 4 months ago. But 4 or 5 months in, you still don't know whether Mr. Bloggs is going to bring a claim. And if he does, well, are people's memories going to be a little bit more hazy?
Yeah.
It's all a bit dim and distant. You might not have taken statements from people at the time. I think everything in changing the time limits is skewed in favour of the worker and against the employer. But it's a philosophical change which the Labour Party seems to think is good for workers, and it plays into the narrative, doesn't it? That most of this is good for workers.
Look, that undoubtedly is good for workers, and look, certainly for those workers where they have a very real case that should be answered. Your point there about almost the penny dropping after 3 months, and actually then realising that you have no legal grounds that you can go back to, I'm all in favour of. I can't help thinking, is there going to be the potential of a lot of wasted time with axes to grind or personal vendettas? I could be completely remiss in that comment, but
no, you
I've seen it enough.
You might well be right. I mean, one angle that struck me only relatively recently was that because the limitation period is longer, if you want to give the worker the benefit of the doubt, you could then say, well, do you know what? It gives both parties a little bit longer to try and resolve
That's a good point.
the issue before someone presses the button on a claim. And if both parties are minded to try and resolve it, that's probably a good thing because it will keep things out of tribunal. So there is a potential positive view or a positive spin you can put on it, and different employers will take a different view. Most people I've spoken to have said they would prefer this not to be the new regime. They'd prefer it to be 3 months,
That's right?
And the rationale they give for that is certainty.
Yeah, and I guess it's a lot you've said earlier and alluded to earlier. Will lots of precedents be set after, of course it'll be after, but you mentioned there sometimes the government like it to be dealt with by the highest courts in the land.
Yeah.
Do you think there will be a natural influx of an increase in tribunals that will ultimately, as time goes on, almost by default sort of narrow things down where, this is legitimate, we put that to bed?
Well, I certainly think there'll be an increase in tribunals. I think if you extend a time period within which people can bring claims, you're naturally going to have more tribunals. On the law of unfair dismissal, the law of unfair dismissal isn't changing.
Right.
So the same rules as to whether a dismissal is fair or unfair will still apply. What we get with the changes is that those rules will apply from day one or slightly modified for the first 9 months. And you'll have 6 months to bring your claim. So I think it's unlikely that as a result of the time limit change and the day one right, I think it's unlikely that you're going to see many cases going through to the Supreme Court. Because the law of unfair dismissal is reasonably well settled. But you might have some technical points that the higher courts have got to deal with. One thing I'm worried about is that this new statutory probationary period might be a little bit like the old statutory disciplinary and grievance procedures. Now, they were abolished a long time ago, but when they were implemented, they were nightmarishly complicated to try and fathom. And the problem is, if you didn't fathom them properly, if you didn't follow them properly, then you were going to be liable for an unfair dismissal. It was just as simple as that.
Cut and dry. Okay.
And I think the government realised that they had become unfeasibly difficult to fathom. They were complicated to follow, and they gave rise to some really odd outcomes. So they were all abolished. And me and my colleagues in the office, when we saw this reference to a statutory probation period, the word statutory immediately set some hairs running, and we thought, goodness, let's hope we're not going to be back in that territory where we end up with a really prescribed, detailed, complicated system that you've got to follow during a probationary period, because that, again, will just increase cost. We talked about tribunals, haven't we? We talked about the number of additional tribunals. And maybe this is for later, but I'll mention it now. The other piece here, of course, is the increased admin burden, and the bureaucracy that all of these new rules are going to give rise to. So if you've got an HR team with 15 people in it now, you might, after these rules come in, you might need an HR team with 20 people in. And because there's going to be so much extra work to do.
And that's a concern for me, Paul. We mentioned at the very start the significance and I'll repeat your terminology, generational change. But what concerns me is what you said, from the one-man bands who employs one person to your multinationals. What you've just mentioned there, like cost, expertise. It's almost going to suffocate some businesses.
And it's definitely going to be disproportionate for the smaller employers. What we thought we might see with some of these rules is maybe exemptions for smaller businesses. Now, that doesn't appear to be flavour of the month at the moment. There don't appear to be those exemptions around. Now, of course, we're not yet we haven't yet got a final bill. So it could be, I don't know, the Lords might propose some amendments.
Right, okay.
There might be some secondary legislation that does give some exemptions for smaller businesses. But at the moment, most of the rules we're talking about today are going to apply across the piece.
Yes, I mean, it's deadly to a certain degree, because it's not just the cost burden of systems, HR departments, individual expertise. It's also, if you don't have that and you get it wrong, the cost to you, it ends up in a tribunal. Your business loses that tribunal. You have to pay.
You're right, and one of the things you can do, and these are products that are already available. You can buy insurance,
right? Okay,
to cover the cost of both legal representation and any award of damages that might be made at the end of it all. Now, those insurers are becoming much more alive to the fact that their product may be worth its weight in gold.
I was about to say that.
Yeah, and I'm not doing the sort of sales speak now, but we don't offer that insurance because we're not insurers, but we do have a relationship with a specialist insurer, and it's interesting. We've seen more people over the last 12 months want to get some quotes, some premium quotes,
right,
so that they can just weigh it up. And it tends to be smaller businesses that are looking for it rather than larger businesses. So there may be another a sort of increase in that market. But these are all going to be things that you can insure against.
Right.
Yeah.
Punt away, definitely. And this is the whole point of what we're here for, is if there is anyone watching now who's employing two people, is to know that, one, you need to start preparing right now, but two, actually, there is expertise through yourself and also who you partner with that can help put insurances into place.
And it's a relatively manageable cost.
Right.
You only have to look at the newspapers to see, almost on a daily basis, a £50,000 award here, one in the news today, a £320,000 award. Those awards are not limited to big employers. Those awards are awards that are made against small employers. And if you got a tribunal judgment against you for £100,000, it might affect whether you can trade tomorrow.
It absolutely will, and that's what I think is the key part. And I think sometimes as businesses, that's the actual open and shut question that we need to ask of ourselves. If the worst happens, does that negate me from being able to go to my office tomorrow, open the door and carry on trading? And again, that's why I'm so grateful that you're sat here and we're discussing this, is because hopefully people's eyes, ears and mouths will be open to the fact of you need to really, really listen to what you're saying, because it could very much be the actual stake of your business.
Agreed.
So So we discussed, or you said a lot, the word statutory, which probably brings us nicely again onto our next topic, which is the changes to statutory sick pay.
Right. Now, this is big.
Yeah.
I mean, I'm at risk of saying all of this is big, but we have chosen the biggest items here to talk about. But this is quite a radical change.
Yeah.
And it stems really from COVID.
Oh, does it?
So there were a lot of people, or should I say, it came into sharp focus during COVID. There were lots of people who didn't qualify for statutory sick pay. And of course, during COVID, there were lots of people getting ill who weren't able to work, and maybe they weren't furloughed. Yeah. But because they earned less than what's called a lower earnings limit, they weren't entitled to receive statutory sick pay. Yeah. The Labour Party said very quickly that they weren't happy with the fact that, and I think it's about 1.3 million people fall under the lower earnings limit and therefore currently don't have an entitlement to statutory sick pay. They wanted to find a way of bringing those people into the statutory sick pay regime. Now, they will be doing that because they're effectively going to abolish the lower earnings limit.
Yes, I read that this morning.
That will bring those 1.3 million people into scope.
Yeah.
But there's another change, which I think is probably even more radical. Currently, if you want to claim or be paid statutory sick pay, you have to wait for 3 days. Yeah. So you only get statutory sick pay on the 4th day of your incapacity. Now, in this sector, back in the day, contracts with workers used to be drafted in a way that said you only have one qualifying day a week, one waiting day a week, and that's Wednesday. So what that effectively meant was they had to be off for 3 consecutive Wednesdays.
Right.
And they might have worked for the whole of the week.
Right.
Yeah, or they might have had an assignment for the whole of the week. You've got to be off work for 3 consecutive Wednesdays before your entitlement to statutory sick pay is triggered. Yeah. In other sectors, it didn't work like that. But in the recruitment sector, there was a lot of that about. I think much less so now. And with these changes, that will be a complete irrelevance anyway.
Yeah. Because
from the minute you're sick, you will be entitled to receive statutory sick pay.
Now, and I can't remember the exact amount. It's 80% of.
It's 80%
salary.
It's 80% of your average weekly pay. Yeah. Or the lower earnings limit.
Right.
So they're going to keep the lower earnings limit.
Okay.
Whichever is the lower amount.
Right.
Yeah?
Okay.
So you'll get it immediately.
Yeah.
And it'll either be at that limit.
Yeah.
Or if you earn less than that, it'll be 80% of what you earn.
Right. And it was, I mean, Labour's whole ethos about this was to protect the lower paid workers, wasn't it? That's primarily where they've focused these, or that's what they've said they've focused these changes on.
Employers have used statutory sick pay as a bit of a stick
right
in the past because it's not set at a very high level.
No.
It's just over £100.
Yeah.
Yeah, £100 a week. And of course, the average wage now is well over 300. It might even be over £400 a week now. So when someone goes off, if their contract says they're only entitled to statutory sick pay, they're going to be earning about a third or a quarter of what they would be earning if they were in work. So that's disincentive number one. Disincentive number two is, well, you don't get anything for the first 3 days. So we're not going to be paying you anything from day 4. Now, if you've got a mortgage and a family, you know, it's
in your best interest to get back to work as quickly as you can.
It is. And most employers, I say most, not all, most employers have a contractual sick pay scheme in place, which maybe gives you full pay for a period of time and it might drop to half pay for another period. But there are lots of employers that don't have contractual sick pay and only operate statutory sick pay. Now, these changes we're talking about today only relate to statutory sick pay, not contractual sick pay. So anybody who's on contractual sick pay doesn't really have to worry about this because the contractual scheme will kick in. It's only those who only get the benefit of SSP who will benefit from this.
So umbrella companies, recruitment agencies that run their own in-house payroll for contractors.
Yeah.
This is, umbrella companies especially, this is enormous in terms of, from a cost standpoint, what it's going to cost us with statutory sick pay from day, because most umbrella companies operate a statutory sick pay policy. Is it open to exploitation?
Well, any scheme that rewards absence arguably is open to exploitation. I mean, I did have a client a few years ago who would regularly ring me on a Monday morning and say they'd only got 75% of the workforce in because the other 25% had been in the pub all Sunday afternoon and had called in sick the following day.
Right.
Now, they had a contractual sick pay scheme. So those people knew that if they were off, they were going to get paid. But the one thing I should say is, whilst I think that these changes potentially might increase the risk of exploitation, it's a common misconception that if someone just phones in and says, I'm sick, that you have to take their word for it.
Yeah. There's contractual caveats.
It's much more difficult if they submit a doctor's note.
Yeah.
If a doctor is certifying in their professional opinion that this person isn't fit for work, it's difficult to contradict that.
Yeah.
But if someone is just self-certifying, goodness, I have been involved in cases where employers have hired private investigators to go and monitor
to
whether actually Mr.
sick.
Jones is sick or whether he's out on the tennis courts or in the pub, living the life of Riley. I mean, that happens, and insurance companies certainly do that in relation to insurance claims that are made. You can still insist on being satisfied that the person is incapable of work.
You can?
Yeah.
Okay.
And most people haven't got the time or the inclination to want to investigate every time someone rings up and says, you know what, got a bit of a cold today, not fit for work. They'll probably just take that on the chin.
Yeah.
But it is still open to you. If you doubt that what the person is telling you is true, you can make investigations. And if they are not incapable of work under the SSP scheme, then they aren't entitled to be paid.
Right.
Simple as that.
But we'd have the evidence of that.
You would need to have it.
Yeah.
Now, do I think this is going to change that very much at all? No, I don't.
Okay.
I think for the sake of qualifying 3 days earlier for SSP, no, I don't think you're going to see thousands of employers becoming much more rigorous in terms of checking whether their people are actually sick. But it's a question that's put to me. Do we automatically have to pay it? No, you only have to pay it if you are satisfied that the individual is incapable of work.
So I own an umbrella company, as you know. Contractually, obviously, as it currently stands, if let's say you were one of our contract employees and you were sick, there is a procedure that you have to follow.
Yeah.
If you don't follow that procedure, then
now I do need to make the point that that's a slightly different issue,
right?
So we act for lots of employers who have contractual sick pay schemes, and they have a list of requirements that need to be satisfied before contractual sick pay is paid. The statutory scheme isn't reliant on those requirements,
right?
So the statutory schemes are much more simple and straightforward scheme. It's much easier to satisfy the requirements for SSP than it might be for a contractual sick pay scheme.
Yeah.
So just because someone hasn't notified you by, let's say, 9:30 on the first day of absence, that wouldn't give you grounds to withhold statutory sick pay, but it might give you grounds to withhold contractual sick pay, depending on how your contractual sick pay scheme is devised.
So I think that this is the point then for recruitment agencies and umbrella companies on the statutory sick pay, which is pretty much 100% of what we have to do. Are you able to, I guess, build contractual parameters that an individual would have to follow? Given what you've just said, yes, you can on contractual sick pay, but on statutory, no.
Yeah, it's going to be much harder for statutory.
So
I mean, I suppose you might be able to go as far as to say, if you don't notify us by this time on the first day, we will not assume that you're incapable of work due to ill health.
Right.
You see what I mean? So almost turn it round and make it a negative. Yeah. I think that's risky because if they then give you evidence, so they didn't call you by 9:30, but they then sent you an email or a photograph, a photograph of a broken arm or them in hospital, or you know what I mean, some evidence that shows that they were actually incapable. Then the fact that you said you must tell us by 9:30 and you didn't, therefore we're going to assume you were fit, that will be blown out of the water.
But surely it's fair that there will be able to be legal caveats that if you must tell us on the first day, whether that be 6 o'clock in the evening.
Yeah, I think that's right. I think what I'm saying is, though, if they don't do that but can subsequently confirm that they satisfy the SSP rules, then they'll be entitled to SSP.
Okay, fine. Yeah. Which is in essence pretty much what we do now anyway.
Yeah.
Fine. Okay. Right. This is probably for me the biggest one. 0 hours and guaranteed hour contracts.
So this is another big topic. Absolutely crucial for the recruitment sector, because what the government have made abundantly clear is that agency workers are covered by this new bit of legislation. There was some doubt as to whether agency workers on contracts for services would be covered, and it might just be worthwhile going back over the history of this,
please.
just so we get some context for it, because Angela Rayner originally said she wanted to ban all 0 hours contracts, and then there was a realisation that maybe she'd been a little bit hasty by saying she wanted to ban all 0 hours contracts, because there was a very swift realisation that there are a lot of 0 hour contracts around, and actually 0 hours contracts add to the flexible labour market. Yeah. So she retreated from that position and said, no, okay, we've had to think about it. We don't want to ban all 0 hours contracts. What we want to do is we want to ban the exploitative ones. Yeah. With no definition of what an exploitative 0 hours contract is. But when you look at what the bill's got in it, you get an idea as to what she means by exploitative. But what I'll say is, even though that was the stated intention, nothing in this bill bans exploitative 0 hours contracts. There are no bans here. What the bill does, it brings in some added safeguards for people who are on 0 hours contracts. So 0 hours contracts are still absolutely fine to use. Yeah, they're not being banned, and even the exploitative ones are not being banned. What the rules do is add some safeguards. Yeah, and the biggest safeguard, which includes agency workers, as I've said, is that after a period of time, which we think will be 12 weeks, but again, not absolutely certain it will be 12 weeks, but let's, for the sake of argument, say it's 12 weeks. After 12 weeks, on a 0 hours contract arrangement, they will be entitled to be offered what's called a guaranteed hours contract. Yep. Now, I'll just explain what that means before I give you my view on it. What that means is that the guaranteed hours contract they have to be offered is a contract based on an average of the hours they've done over that previous 12 weeks. So you tot up all the hours, divide them by 12, and that gives you your guaranteed weekly hours contract. That has to be offered, yeah? And I'll come back to who has to offer it in a second. That has to be offered. But importantly, and this is a bit that tends to get missed, importantly, there's no obligation on the worker to accept it.
I read that. So I read that bit this morning. And in fact, that's what I've got on some of my notes here. The worker can actually reject the guaranteed hours contract.
They can. And, you know, some people have said to me, well, so what? And I say, well, I've been in this space for a long time. My view is that most agency workers don't see themselves as ordinary employees.
Yeah.
They regard themselves as in a slightly different category. And And I think because a lot of workers choose to be on a 0 hours contract or a contract for services that doesn't guarantee any hours, they will continue to want that flexibility. So yes, they'll have an entitlement to be offered a guaranteed hours contract, but my own view is a good number of them will say, do you know what?
Don't need
no,
it.
thanks.
I'm the same. I've got a friend now. She is a carer, works for the NHS, as and when time and the care permits her to. And we had a very, very brief conversation about it. But she was exactly the same. She's like, I like my arrangement.
Yep.
It's perfect for me if I can pick up some shifts because some additional care to relieve me has come in. I can still pay to put food on the table. I can still pay my mortgage. I can still care for my mum.
Yeah.
But it gives her the ability to go to work.
Yeah.
And I think you're quite right. That doesn't get reported as much as what the changes in or what they wanted to do in terms of stopping exploitative 0 hour contracts. But I share the same opinion as you. I think that especially contractors, I think a hell of a lot of them will be like, thanks, but no thanks.
Yeah.
This is the exact arrangement I want to carry on working.
And that's why people do this. That's why people sign up with an agency. They do it. Some people do it because it's the only option.
Yeah.
But in my view, most of them do it because they make a positive choice to do it. And they do it because it provides them with ultimate flexibility. So, yes, they'll be entitled to a guaranteed hours contract, but I think you're going to get more people saying no to it than saying yes. But the one interesting thing I wanted to mention to you about it, and this has the potential to really change the landscape, and you might be surprised when I put this to you, the obligation to offer the guaranteed hours contract is not on the agency.
It's from the end client.
It's on the end client.
Does that not automatically then, from an agency or an umbrella standpoint, mean that you've instantly got an employer-employee relationship?
Well, I mean, you've hit the nail exactly on the head there, because you'll have gone, let's say Mr. Bloggs says, yes, thank you very much. I really do want that guaranteed hours contract. I'll accept it. Well, at that point, Mr. Bloggs won't be an agency worker, won't have a contract with the agency anymore. He will become directly employed by the end user client, and he will definitely be an employee.
Yeah.
So he's gone from being a contract for services worker with not all of the employment rights that you get as a result to being an employee.
Oh, wow.
So that changes the nature of the contractual relationship.
100%.
The agency then loses a worker. And then there's a question around transfer fees.
That's what I was about to say, is actually the business model from a recruitment standpoint. Now, you've almost, well, it's just been blown up.
Yeah, I mean, transfer fees the government has said they don't want to interfere with transfer fees.
Of course they
So
don't.
transfer fees technically will still be available. But which client in their right mind will accept a contract that has a transfer fees clause in it now?
I wouldn't.
If they're under an obligation to offer a guaranteed hours contract, first of all, they'll be probably quite upset about that because they might want the flexibility of using an agency worker instead. So they've got to get over their upset about having to offer a guaranteed hours contract. And if the worker says, yes, I'll take it, then they've got to take them on their books and treat them as an employee. Are they then going to want to pay a transfer fee on top of that?
No.
Absolutely not. So it's fine for the government to say they're not going to interfere with the ability to charge transfer fees. That's fine, but you've got to think through the next sentence. The next sentence is, but which clients are going to entertain a transfer fees clause?
And by the very nature of what they've done, that's what's going to happen.
Yeah.
So
I think we are going to see the end of transfer fees effectively.
You do?
Yeah, and the government are not going to legislate to ban them. They've said that, but I think they're either being ignorant or stupid, because if you think it through, most clients will say, if we've got to take the risk now of a guaranteed hours contract offer, the last thing we want is a $5,000 or a $10,000 transfer fee.
Yeah.
No chance.
So how's that going to operate then?
Well, it could play out in several ways, couldn't it? But I think the loser in every single case will be the agency, because the agency will lose the worker. the agency will lose the ability to charge a transfer fee.
So the income.
And we're not even in extended hire territory here, because you know that the rules around transfer fees are that you offer an extended hire period, and if the client says no to the extended hire period, you can charge a transfer fee. If they say yes to the extended hire period, then you can't charge a transfer fee. What you might end up with is a situation where you still have the transfer fees clause in the contract, with an extended hire period clause, and the client in every single case takes the extended hire period. But the problem with that is, you see, this is why this is such a wonderfully complicated topic. The problem with that is, if your extended hire period, let's say, is 12 weeks, but you've had to offer a guaranteed hours contract before the extended hire period kicks in, the extended hire period is going to be no use to you. You can't give an extended hire period because the law says you've got to offer the guaranteed hours contract, and if the worker takes it, they start. So the government have said they're not going to legislate to ban transfer fees, but the very impact of these rules means that transfer fees, I think, are now dead and buried.
Sorry,
it's huge.
I was going to. That's why I'm so silent.
Yeah.
I'm trying to, in my head, think. So I'm a recruit. Okay, is there a way that recruitment agencies can? I'll use the word bypass, and I'm saying this from a complete novice idiot standpoint. Is there a way around it?
Well, currently, with the bill as it's drafted, the answer is no. But the government have given an indication that they are still looking very carefully at how these provisions might impact agency workers and agencies. So they've not said what we've got now is the final view or word on it. They are saying to organisations like the REC and APSCO and others, we recognise that agency workers are in a slightly different category, so we are continuing to look at it. Now, they might look at it and decide they're very happy with what they've come up with, or they might look at it and say, do you know what, we do think we need a couple of tweaks here and there. So what we end up with might be different to what we've got now. But currently, I can't see a way around that practical outcome. I mean, the government are right. They're technically right when they say they're not going to abolish transfer fees.
Yeah, but that it's a soundbite, though, isn't it?
Yeah.
And it's a very, very well-positioned
the practical
good one.
reality of it is no sensible client, in my view, will say yes to a transfer fees clause. So what that might result in is agencies trying to charge more per hour.
Yep.
They might increase their rate. What they might look for is some sort of, instead of maybe some sort of upfront payment.
Down payment, yeah, that's what I was going to say.
Which is not a transfer fee. So there may well be some creative thought given to how agencies can protect what is ultimately their asset. I mean, their asset is the worker.
But Paul, how many, and I look to the camera and say this, how many recruitment agencies sat here watching this now understand this part, or are ready for it, or are prepped for it? And I appreciate what you've said in the fact that, okay, it's not a foregone conclusion yet, but it's that whole preparing for the worst.
Correct. And again, to be completely even-handed, I have a lot of agency clients who never think about charging a transfer fee.
Right, okay.
They never put a transfer fees clause in. Or they say, we'll give you a free transfer as long as you engage them for a minimum period.
Right, so, okay.
So for those people, this might not be such a radical change. But I think working it through, it could affect a lot of agencies. Yeah. So sorry, we're only part way through these 0 hours protections. Yeah. So the first one is the guaranteed hours.
Right.
The second bit, and this is the exploitative piece. So you can see what the government's angling at here. Imagine Mr. Smith gets a call. Sorry, I should be even-handed. Mrs. Smith gets a call from the agency one morning at 8:30. And the agency says, we'd like you to turn up to our client for a 9 o'clock shift, please. Yeah. And she thinks, oh, yeah, actually, I could do with some work today, but I haven't got any childcare. And if I buy a same-day return train ticket, it's going to cost me 80 quid. But I'll do it because actually, I could do with this day's work. So she buys in some emergency childcare. It costs her an arm and a leg. She buys her return train ticket, jumps on the train, gets there a little bit later, maybe 9:30, and then the supervisor says, "Oh, I'm sorry, we've already filled the shift. We managed to, you weren't here at 9:00,
right.
so we got someone else in." So she then has to go back home, having incurred the childcare, having paid 80 quid for a return train ticket, and she's not had any work. And what the government has said is that's not on.
Yeah.
Yeah, that isn't right.
And I agree with that.
Exactly.
100%.
Exactly. So if a shift is cancelled, or if it's modified, or, you know, some people even turn up and the supervisor says, "Oh, sorry, yeah, we did say a 9:00 shift, but actually we meant a 1:00 shift." Yeah. Or, "No, we haven't got anything today. Sorry, we got that wrong. We've got a shift tomorrow." Yeah. So the shift could be modified, or it could be curtailed. She thinks she's turning up for an 8-hour shift, and after 4 hours, the supervisor says, "You can go home now. We don't have any more work for you." Yeah. So a modification, a curtailment, or a cancellation will all now give rise to the ability to bring a claim for compensation. So Mrs. Smith will be able to claim for any losses that she's incurred as a result of that. And she'll also be entitled to effectively penalty payments. We don't know what they are going to be set at,
right.
But if the shift is cancelled, modified, or curtailed, she'll be entitled to a payment. Now, on the compensation side, the proposals at the moment are structured in a way as to make both the end user client and the agency liable for that compensation, because it may not always be the client that has caused the problem. It may be the agency. The agency might have been told about this shift the day before, but only rang Mrs. Smith at 8:30 that morning. She's not had reasonable notice. She's not had reasonable notice at all. So the responsibility there for the compensation will probably sit with the agency. But there may well be circumstances where the client rings the agency really late on. The agency passes on the message really quickly. Well, reasonable notice there hasn't been given by the client. So the client will be on the hook then for the compensation. Yeah. So we've got this interesting sort of potential split liability depending on who's more to blame than the other in the supply chain. And of course, if you get an umbrella involved,
I was just about to say exactly
you've got another party that might well
Absolutely.
be liable. Now, we're quite familiar with this, aren't we? Because if you think about the agency workers regulations, that has provisions in it that splits liability between the end user and the agency or the umbrella. So we're quite familiar with that. The position in relation to penalties. So the penalty payments that I've talked about, not the compensation payments for not giving reasonable notice, the penalty payments, they are going to fall at the door of the agency.
Right.
The agency will have to make those payments. But the government are giving the agency the ability to have a clause in the contract with the client that says the client will reimburse them. Now, let's just think about that for a second, Rob. Yeah.
Oh, no.
Yeah. That's great. The agency said, well, that's absolutely fine.
Yeah.
No worries. We'll just pass the cost on to the client. The client either will say, on your bike, I'm not signing that contract.
Yeah.
Or if they do sign the contract and the agency tries to pass on the cost, the client will say, well, thanks very much, but we prefer that agency down the road.
Well, I was just literally...
So we'll go down to them next week.
When you were explaining all of that, I was in my head thinking, how many relationships are literally just going to be nuked?
Yeah.
Like, and
well,
again,
we get claims now under the agency workers regulations. So an agency brings a claim. An agency defends a claim. The worker brings the claim. The agency sends us the papers and says, will you represent us? And we'll say to them, well, actually, it's the end user client that's liable for this because they didn't do X, Y, and Z. You know, you ask them the question, for example, about parity pay rates. They didn't give you the answer, or they gave you the wrong answer. You can pass the liability on. I can count on the fingers of one hand the number of cases where the agency client has said, oh yeah, go on. Let's sue the client.
Yeah.
Let's write a letter to the tribunal to get the client brought in as another respondent.
It's not going to bite the hand that feeds you, are you?
No chance.
Exactly.
Absolutely no chance. So this is a similar situation.
Yeah. But then some agencies, I dare say, will go with, yeah, well, that's fine, we'll pass that on. and almost we'll deal with it if and when it comes to it.
Where I've had agencies who've said yes to joining in a client is where the relationship's broken anyway.
Right, yeah.
So if the client's already said we don't want to use you anymore,
doesn't matter.
Agency thinks I've nothing to lose here, I might as well.
Yeah.
But if there's an ongoing relationship where they're supplying workers on a regular basis, they're not very keen.
But in a positive way, then, there's definitely and clearly the ability here for agency client to seriously strengthen that relationship, to be able to sit down like you and I are now and really hash it out and say, okay, this is what it means, this is what's coming, this is what we're going to do to ensure that we are literally as strong as we can be.
I think there is, and it's difficult to put a positive spin on this legislation, isn't it? But this is one area where you can.
Yeah.
There really is the opportunity for agencies and end users to collaborate here. You can avoid these penalties. You can avoid these claims for compensation around zero-hours contracts, lack of reasonable notice, curtailment, modification, all of that, penalties, if you communicate properly. Yeah. So if you've got a good arrangement in place where you both understand each other, good lines of communication, no one can blame anybody else for having sat on their hands, you are going to avoid these claims. So and it strikes me that type of collaboration, as well as avoiding claims, is just generally good.
100%
for the relationship. It strengthens the relationship.
And are you seeing that happen already?
Yeah, well, again, if I'm being bluntly honest with you, more agencies than end users are aware of these changes.
Right.
End users at the moment are not particularly au fait with them. So I think there's an education piece from the agency to the end user.
And I think that's, you look at, and you've quite rightly said, there's not much positives from this in general. But that's definitely one. And to be able to go out now, and I mean, it's almost a bit of a business development tool, isn't it? To
I agree with you.
To say, are you aware legally of what's coming?
Yeah, we work really well 100%. With you. You're a valued client. We've got some up-to-date information on these changes. They are going to impact on this relationship. And we want to sit down with you for an hour and we want to talk you through it and find a way of collaborating.
And if you're doing that and I'm not, I'm going to lose out.
All right, agreed.
So, and this is the thing, I think, and this is why, again, I repeat for the 90th time, but so grateful to have you on. I'm conscious we've got about 10 minutes left. And is that sort of, is there still more on the 0 hours?
No,
and the guaranteed?
I mean, that's it as a broad framework. Yeah.
Okay.
But there's enough there, isn't there? I mean, there's a lot to get you.
And I think that's the thing is, there's a lot to digest in terms of what you've said.
Yeah.
That said, in terms of if it's not piqued your interests, then do you know what's coming your way is almost to a certain degree expected. I don't think we're going to get through everything, but if we can spend the last 10 minutes on the new Fair Work Agency.
Right. So again, this is big. I'm sick of saying that word this morning, aren't I? It is big, but perhaps not too much of a surprise. There's been talk for a number of years about a single enforcement agency.
Yep.
And the Fair Work Agency is that.
Right, okay.
So currently you have the GLAA, the Gangmaster and Labour Abuse Authority, with quite a big remit and around modern slavery and exploitation of workers certainly in recruitment.
Yeah.
You have the Employment Agency Standards Inspectorate, which is run by a guy called Ben Bruton, a really nice guy. Was on a platform with him last week. And you also have the National Minimum Wage compliance arm of HMRC.
Yeah. And
currently they all operate independently. Over the last few years, they've collaborated a little bit better than they have previously, but they're under 3 different roofs. And what the Fair Work Agency will do is it will bring them all under one roof.
Okay.
Yeah. So they will be completely coordinated.
Right.
So the GLAA will cease to exist in its current form. All the functions will go into the Fair Work Agency. Same with the Employment Agency Standards Inspectorate. And we think HMRC's National Minimum Wage powers will also go into the Fair Work Agency.
Right.
So the Fair Work Agency will have regulatory responsibility for all of that. Yeah. And I think that's a good thing.
I do.
Yeah,
I do.
because it will drive standards.
Provided it's well resourced.
You've hit the nail on the head, and that was the biggest point that came out of a session that I gave last week on this. Everybody said, in principle, this sounds great, but when you then talk to the individual, you talk to the GLAA and you talk to the Employment Agency Standards Inspectorate, they don't have huge budgets.
No.
And my worry is that if you just put those budgets into another entity, you're not going to have the enforcement strategy, the enforcement ability that the Fair Work Agency, I think, really requires.
Yeah, agreed.
Yeah. So that's the sort of overall strategy, which I think is a good thing, subject to resources. But there are a couple of weird bits that the Fair Work Agency will be able to do, and I'll just raise one of them. Rather weirdly, but you can understand. I think you can understand why. The Fair Work Agency will be able to bring litigation, bring tribunal claims on behalf of people, even when they don't want to bring a claim themselves.
Yeah.
So let's say Mrs. Smith says, I haven't had my holiday pay properly calculated for the last 3 weeks. I've been on leave. And the Fair Work Agency get this and they think, well, actually, out of that employer, we think everybody's had their leave incorrectly calculated. We need to do something about that. Well, the only way they can do something about it is by claims being brought by the individual workers. So even if Mrs. Smith says, but do you know what? I don't want to rock the boat. I don't want to bring a claim. I maybe bring a grievance, and if they pay me a bit more, that's great. If they don't, well, we'll call it quits. Or I might move on somewhere else. And the Fair Work Agency can say, no, we think it is, as a matter of principle, we should bring that claim, and we're going to bring it on your behalf. So even though she says she doesn't want to bring a claim, the Fair Work Agency brings it for her. Now, I can see what's behind that, because it gives the Fair Work Agency an opportunity to try and stamp out bad practice on a wholesale level. But do we really want to be bringing claims for people who are positively saying they don't want claims to be brought? It strikes me as a little bit odd, even though I understand the rationale for it.
It's that middle ground, isn't it?
Yeah.
It's, because there are exploitative businesses. We know that, and, the GLAA will tell us that. They have told us that. But you're absolutely right. But then that also, for me, it's all well and good them saying that they can do that. But if it's not resourced well enough, are they even going to be able to do it anyway?
Well, correct.
So with, and I, bizarrely enough, I looked at this in quite a lot of detail this morning. I couldn't help thinking, and you and I have worked with government departments and been involved with them for many, many years now. I read it and just thought, is this just going to be another piece of hot air in terms of, as you've quite rightly said, the principle behind it? I'm all for. I think something like that should exist. It's been long overdue. I mean, the single enforcement body was actually the Conservatives' brainchild, wasn't it?
You're right.
So that's how far
never
we
got off the ground.
No, it didn't go anywhere.
Yeah.
And ironically, I know lots and lots of people basically said that as well. This just won't happen.
Yeah.
So I'll applaud Labour in the fact that this is something that they look like and very much appears is going to happen.
Well, if it improves the position, I'm absolutely all for
100%.
it. And entirely coincidentally, we didn't know that this would happen today, did we? But this morning, they published the name and shame list for the national minimum wage non-compliance.
I've not seen that.
Yeah, so that was hot. I literally managed to scroll through it before I came here.
Right.
500 and odd businesses who have been named and shamed for failing to pay the national minimum wage. There are some very big names on that list. So go away and have a look at it. And my point is this: if that list becomes shorter as a result of the Fair Work Agency, then it will have proved that it was the right thing to do. But if the list stays the same or it gets bigger, do you know what? Was it really worth it?
And that's I guess is what I'm like you. I'm holding out for. And ultimately, if the list gets shorter, it means people are being paid what they should be. And that for me is I'll champion that all day long.
Absolutely right.
Paul, honestly, I could, if we had 10 hours, I'd sit here with you for 10 hours. You've probably done a lot of people many favours this morning.
Well,
This is the quietest
Yeah.
I've ever been on a podcast as well, which is testament to your expertise. It's been a privilege, honestly, buddy.
No, it's been an absolute pleasure.
We have literally discussed the fraction as well, haven't we?
Yeah, we have. There's a lot more to go at. So hopefully we'll get a chance to do it again.
I was going to say, should we see how the summer pans out?
Let's do that.
What's announced, what's not, potentially.
Yeah.
And let's definitely circle back for another episode.
Perfect.
But genuinely just wanted to say thanks very much.
You're very
bud.
welcome. Thanks very much.
Thank you so much for joining us for the first episode of season 2. I hope you find this episode as valuable as I did. Businesses, genuinely, this employment bill is happening. Paul's information, his guidance, everything he's discussed today is genuinely there to help you. Please, please, please do digest it. Aside of that, really look forward to seeing you in the next episode. Please follow us on our YouTube channels, Spotify and Apple, where you can download all our episodes to date. And I look forward to seeing you next time. Many thanks.